Members, this morning we have one item on the agenda today. It is House Resolution 128 by Pro Tem Magee regarding relative to contempt of the special committee to inquire into the circumstances and investigate of the death of Ronald Green. Mr. Pro Tem, on your resolution.
Thank you, Mr. Chairman. Thank you, members of the committee. Let me first start out by saying I had no desire to be here today. This is not anything that I would want to do or desire to do, but this is where we find ourselves, and I'd like to give you all a little bit of the journey that got us to this point. I was appointed to do this task as chairman of the committee. I didn't ask for it. I didn't seek it out. I was appointed by the speaker, and I only agreed to do it if the committee itself was bipartisan and that had a makeup of quality of members, not just quality but diversity. And if you look at the committee itself, not just in racial breakdown, not just in women breakdown, men breakdown, it's a great diverse background of people. We have Representative Villia, who's former prosecutor, Representative Bacala, former law enforcement. We have Representative Marcel, who is I think has a reputation as a social justice warrior. We have Representative Mandy Landry, a brilliant attorney, progressive. I think we've really hit all the fronts. I'm leaving out Representative Hughes. I can go down Representative Nelson. They're all great. And if I've left anybody out, Representative Jordan, another super intelligent attorney. So that was why I agreed to do the committee. I would not agree to do it otherwise. And when the speaker gave me my appointment, I told him, I said I would do my best under the instructions you give me to find out the truth. And if that leads to you, be aware that I will find that out towards you yourself. So if you give me this task, I'll do everything I can within my ability. And I want to read a little part of the letter that he wrote appointing me so we have an idea of the scope. It said, "This letter is to advise you that I've appointed you to serve as a member of the special committee that I've put together to review the handling on all levels of the Ronald Green incident, including receiving testimony from individuals and government employees and officials related to the incident. I looked at this committee to provide answers to questions regarding the incident and its handling that would assist all members of the legislature as well as the public in understanding and help the state to move forward." That was my initial charge, members. And so that's why we got here where we are. The committee itself, when we started looking at witnesses who we'd call, I allowed the committee to do that. We had an organizational meeting. I left it up to all the members of my committee to say who they wanted to hear from, what documents they wanted, and we put together a list that's been a master list that we've been using to schedule. And I also want to take a note at this moment, talk about, you have green cards today from every member of my committee save one in support of the resolution, and the only one who doesn't put a green card in is Representative Marcel, who's not here for health reasons. So I'm confident she would have put a green card in if she would have been present and able to come.
And it looks like she's a co-author on the resolution.
And co-author on the resolution. Every member of the committee is a co-author on the resolution. First meeting, we ID witnesses and documents, and then I've been using that to go through. On the March 15th meeting, we had Colonel Reeves come testify. I was notified by his attorney, Mr. Unglesby, that he would be present, he would attend. We were very appreciative and gracious that he decided to come on his own. We didn't have to do anything to make him come. That was great news. And so we've been communicating with Mr. Unglesby ever since. At that first meeting, Representative Villia, Representative Mandy Landry, and Representative Bacala asked questions about how he kept notes in meetings. And I want to be very clear. I think it's been reported that this is like a journal or a diary. It's really not. It's a journal and diary in the sense that that's what you would call the book it's written in, but it's a notebook containing meeting notes. And you can verify that by looking at what is in your packets. You can see the pages that have been produced of that document, and it's very clear that they're meeting notes taken as he is having meetings. We went from there, and I'm about to turn it over to Ms. Representative Villia in a second here, but one thing I want to do is we have agenda like we do every committee meeting for every single one of our meetings with public notices, giving everybody an opportunity to testify. At the meeting, the journals were discussed, they were identified, and we sent a letter of request, and now I'm going to turn it over to Representative Villia to go over kind of what happened to get to this point.
Thank you. Representative Villia.
Thank you, Mr. Chair. I'm pouring some water. Unfortunately, my voice is not good.
No problem. I take this pause to go through the cards. Filling out a card in support, wishing to speak, Pro Tem Magee. Filling out a card in support, Representative Villio. Representative Jordan, willing to provide information in support. Representative Bacala, willing to provide information if requested in support. Representative Nelson, willing to provide information if requested. Mandy Landry, willing to provide information if requested. And Representative Jason Hughes, willing to provide information if requested. All green cards, all in support. Representative Villio.
Thank you, Mr. Chair. Let me first say, for those of you who don't know me well, I have spent my entire career, more than 30 years, standing on the side of law enforcement. First as a prosecutor, then as criminal justice director. In my private work, defending civil rights actions for police, and I believe here in the legislature, sitting on the Criminal Justice Committee, where I dare say there's no one who will say that there is a fiercer proponent for law enforcement. So it pains me to be here today, but it is where we are. And I am committed. I, like the Speaker Pro Tem, didn't ask to be on this committee. I was put on this committee, and I am always going to do my job to the best of my ability. I have been, unfortunately, amazed at some of the testimony I've heard and disappointed beyond belief in the testimony that I've heard. With that said, relative to Colonel Reeves, when he first testified on March 15, 2022, I specifically asked him whether he kept a journal of notes from staff meetings, notes from disciplinary meetings, notes on high-profile cases, and he answered yes. And anyone who knows me knew that I already knew the answer to that question before I asked it. And when I then asked him on March 15th to produce that journal, he denied that request. And following that, the committee issued a written request for his journal. And it's very important to note, we like to get caught up in talking about with state officials, public records, while it is unquestionably, in my mind, based upon the testimony of Colonel Reeves, that he took those notes simultaneously with those meetings. It's a public record. Let's not get caught up in whether it is or it isn't, because that's not the case law here. And that's not important. We ultimately subpoenaed those documents. And I'll get to that in a moment. But on March 29th, we issued a written request to Colonel Reeves through his lawyer, Louis Unglesby, for the journal, for those notes. Subsequently, we received word, twice, we received word back from Mr. Unglesby that he was going to be out of town in depositions and couldn't respond at that time. And then on April 13th, we received a letter from Mr. Unglesby that they have no Ronald Green documents. Members, that's patently false. And we know that because later on, when some snippets of documents were produced, we know for a fact that that statement was patently false. On April 19th, 2022, Chief Sergeant at Arms Clarence Russ served the subpoena on Colonel Reeves through Mr. Unglesby. That subpoena was served at 900 North Street in Baton Rouge, the 12th floor, and it was signed by Elisa Westmoreland. And we're here today because we have been denied, yet again, the committee has been denied those records. And the committee on May 11th met, and we took a vote. And unanimously, we found Colonel Reeves to be in contempt of the subpoena for failure to produce those records. Now, when one wants to look at whether or not those records are important in the scope of inquiry into the investigation of the death of Ronald Green and the handling of the death of Ronald Green and that investigation, there can be no doubt that those records are critical to this investigation. And I'll give you one snippet of a record that we did get to see. And that is in October of 2020, the governor's staff, Tina, saw the infamous Lieutenant Clary video. What's important about that, members, is that video allegedly was not known to exist and not found by the state police audit team until 6 months later. That note was in October of 2020, and no one supposedly knew about that video until April 2021. Now, this is after we received a letter that they had no Ronald Green documents. So it cannot be understated how important, or overstated, how important the notes in that journal, that book, that notebook, whatever you want to call it, it is critical to the complete investigation and handling of this matter. And we believe the subpoena was appropriate, and we'd ask that you find so. Thank you.
Thank you. Mr. Perkin, you got anything else?
Yeah, I'll just add just a little touch on a couple of things. We gave it an original due date of April 5th on our request. We did not get a response by April 5th. We gave it an extension because he said he couldn't do it until April 13th. We did not receive a response until after that due date was produced. Then he said that he didn't have the documents at all, that there was no Ronald Green documents. Eventually, he did produce a certain amount of pages, and you'll see that Ronald Green is specifically mentioned in those pages. So that was, and I don't like to say these things and accuse people of things, but that was an outright lie. He outright lied to the committee when he wrote that in that letter. There's no other way to look at it, right? There's no other way to look at it. And to this date, as we sit here today, he's never produced all of the journals to this committee that were requested. He's reduced pages. And I want to be very clear and upfront with the committee. I offered to hold those journals under seal like we're doing other Louisiana State Police documents right now. I mean, nobody can get them. They're in the clerk's office. I get to review them. Members can get to review them, but they stay in the clerk's office. Nobody gets to take photos of them, and we don't disclose what's in those documents. I offered to go through it and redact it with them. If there was anything that was sensitive, we could redact those words from those pages. I even offered and went to his office to review the journals with him so that we could come to an agreement on certain pages. During that process, we got to a page and there was a disagreement about whether it was related to the Ronald Green matter or not. I think it was. It referenced police brutality. And to me, anything that referenced police brutality in the journal of the superintendent of state police during the Ronald Green time period is relevant to our inquiry. He said, no, that's not relevant, and that's not what that's about, and refused to produce that page to me. That's where our discussion ended, and I left there. He offered to give me the 11 pages. I refused him. I said, because I want the entire journals. Then that was the second lie he told y'all, because he writes in a letter that I left, and I may have inadvertently left the pages behind. That is the second outright lie that he told to now this committee. Because under no circumstances was I even unclear about my intentions. I told him I was leaving with the journals or nothing. And there was no way you can mistake that. All of it witnessed by other people who were around this time. So I just want the committee to know the level that we have had to go through to try and get these documents. It did not come easy. And it's not like we're coming here and we're just wanting to be here. This is the last resort for us to get what we believe we are entitled to under the Louisiana Constitution, Article 3. And with that, members, I turn over for any questions you may have.
Representative Horton for a question.
Thank you, Mr. Chairman. Thank you. Thank you, Representative Magee and Billy O and the entire committee. I mean, we do, as you bleed blue. But even my friends that are state troopers, who I of course would not name, know when the law enforcers do not act contrary to the very law that they do enforce, then they must be held accountable. I want to ask you, Representative McGee, did you see the notebooks? Did you see it in its entirety?
I was able to review one complete. There's 3 notebooks.
Okay.
That I'm aware of. I have to take them at their word that they're 3. I mean, there's no way for me to verify otherwise. There was 3 notebooks. One was kept hidden from me the entire time. I was never able to put my eyes on it, other than a reference was opened up. It was kept in a accordion folder, and he opened it up to let me see that it was in there, and that's the last time I got to see it. Two notebooks were on Mr. Unglesby's table. I was able to review one of them in his presence. I marked pages that I thought could be of interest that I wanted to go back and discuss with him about producing those additional pages. I got into the second notebook. It's hard to know if you're a quarter of a way, halfway, or where you are in a notebook because you don't get to the end of it. And I was stopped on a certain page that he refused to produce, and our discussions broke down at that point when I marked that page for discussion. So I did review one. I can tell you, Mr. Unglesby has told me repeatedly that there was sensitive information about things unrelated to Ronald Green. I did not, in the one and possibly a quarter journal that I reviewed, I did not see tons of sensitive information. Most of it was meeting notes on hurricanes.
So even if there is sensitive information in those notebooks that is not related to Mr. Green or the Green family, like you said, those could have been covered up.
Redacted.
It could have been protected. So there's no reason for not to turn those over.
None. And look, we have the ability to, and we've done it already in this committee. When I refer to this committee, our committee on Ronald Green, to keep things under seal. I mean, we have the investigation of a number of state police members under seal right now, and they have remained under sealed.
Well, thank you, Mr. Chairman. Thank you for doing your due diligence on behalf of the citizens of Louisiana and the family of Ron Green.
Thank you, Representative Horton. For question, Representative Johnson.
Representative Magee, the parameters of your authority and investigation of your committee are laid out fairly clearly, are they not?
They are. Absolutely.
They're not boundless, but they have clear parameters of what you are charged and authorized to request, do they not?
They are, and we also put that in our subpoena when we sent it out too.
And Colonel Reeves' part in this investigation, just for our clarity, is what position did he hold during the relevant times that we're investigating?
He was the superintendent of state police, and one of the things I think I knew, but I didn't really completely understand at the time until I started doing this, is state police is an agency like LDH, but they don't have a true secretary like LDH has. Technically, Jimmy LeBlanc is the secretary over state police. But as Jimmy LeBlanc testified to our committee, he has no real involvement at all with state police. It's basically a technical deal. The governor and the superintendent of state police reports directly to the governor on all matters. And so he is, by de facto, the secretary of state police. I mean, he's the top man.
And in a perfect organization, he would be the focal point of where all of information would flow to. Is that correct?
That's correct.
So of all the people that you may interview, if the organization is performing correctly and honestly, he would be the person that all that information of all people would come to.
Should be, yes.
And these documents, journals, notebooks, whatever you call them, did you had a chance to question him under oath in the committee?
Correct.
And did you ask him why he kept journals or notebooks?
And that's why I brought Representative Vilio with me today. I am just like Representative Stefanski, the person who's trying to keep the train on tracks, right?
Right.
Representative Vilio, Representative Bacala, and Representative Mandy Landry expressed interest in the journal for good reason. I support their interest in it. Right. So they were the ones who were questioning him on that point. And it was my understanding and impression of his testimony was that he did this in all meetings he ever was in. Okay. He kept notes.
And meetings meaning meetings as the superintendent of the state police.
Correct.
Did you get an idea of how far back these journals, their origin was?
it seems to be his entire time as superintendent, as I can tell. I will tell you that, and one of the things I think that what I think is really important about the journal itself, even if it doesn't have any sort of smoking gun sort of information,
Right.
it establishes timelines with dates, because a lot of people's memories on thing are not focused. But here we have somebody who's record keeping in real time, writing down time and dates. And so when he says, had a meeting with so-and-so about this, it was sometime in March. Now you can go back to the journal and you can figure out when that actual meeting was, which is really important for our committee's purposes.
Well, it also gives you a basis or a blueprint to then go and question the person who he may. In fact, keeping it sealed for the committee actually gives you more leverage or more insight to get perhaps truthful answers from the people who are listed in his journal as having met with.
Correct.
And this is something I did not know. I find this very interesting, is that you have offered and made it clear that your request comes with an assurance that it will be taken in for an in-camera or private review to determine if it is job related, state related, open meetings related, as opposed to, went to a barbecue with Bill and Smith on Labor Day of 2018, something like that. You have offered that so that there is no personal, for the purpose of providing protection for any personal and irrelevant information.
Correct. And I would also tell the committee that it was represented that by Mr. Oglesby that there's a lot of personal information in there. In my limited review, I saw no personal information in it at all. It was all public information, business related. If there was some private information, I have no interest in any of it. We would keep that completely redacted or hidden from.
But much the way that we're practicing attorneys, much the way we would make that objection to the court that discovery is irrelevant, it would be the judge who would then take possession of those documents and determine whether the requested information was or was not relevant. Would it be?
Correct. But I would like to err on the side of caution on producing in this stuff, because I do believe there's a lot of potential sensitive stuff in the journals. So I have no desire for anything that's even remotely not related to this.
Let me question you as to the quality of the information that you have received. You've reviewed all of the documents that has been presented to you.
I have.
In response.
Well,
And-
let me say that all the stuff that he presented, we got over 3,000 emails from state police. I've not been able to.
And my fault. My question wasn't clear. You have reviewed all of the documents that you have requested that have been provided from this particular witness.
Correct.
And do the notations and the diary notes or journal notes appear to be well written and concise?
They are. He writes in a shorthand that takes a little bit of thought to look through and to figure out. It's not. They're meeting notes. I mean, they're
Right.
not. He's not journal entering, telling you his deepest thoughts or anything like that, or saying for prosperity. They are shorthand. Using of, but it's very clear. He dates everything. He puts a subject on the top of it, and he squares and he boxes it in, and he even puts a time on most of it. So I mean, it's pretty clear what he's doing.
So would it be fair to say that there is probably no better source of contemporaneous information collection than the notes and the journals that you are requesting?
Correct. Absolutely. And like, for example, I think the entry from 5/22/19, which is in your packet, guys, is tremendous. And if you look at it, it says in custody death, 9:30 a.m. video issue. So we now know for the first time when Colonel Reeves was aware that there was an issue with videos related to Ronald Green. And then it says review of past videos. So now we know we're getting in his mindset that state police is aware that there may be an issue with past videos of state police. And then he says, realize there's a problem, must address immediately. Now this is 3 years ago, guys. And where are we now in that investigation? Order to comply with policy or cameras issued by captain, open in, and then look, suspend, penalize, criminal. So we now know in the mind of Colonel Reeves, he knows that the investigation of Ronald Green has led to something that's potentially criminal. And then it says admin leave. None of the officers were ever put on admin leave. So we know that he was considering admin leave. Now we're trying to figure out, why didn't he go into admin leave? Video audit of Hollingsworth's history, Hollingsworth being one of the troopers who was involved in the incident. So this is telling you way back on 5/22/19 that these questions had made it to the superintendent's level. And we now need to try and figure out, what did he do with that information, and why did he recognize the problem and then later back off the problem and say stuff like awful but lawful, various things, when we realized back in 5/22/19 he did not necessarily think it was lawful.
And you did not have the benefit of any of these notes when you took his testimony,
Did not.
and you've not questioned him since then.
Did not.
And it would be most obvious that if you had all of the notes, this would provide you with an opportunity to better understand and get an explanation from a subsequent examination of this witness, would it not?
It would.
All of this was collected while he was on the payroll for the state of Louisiana.
Absolutely.
All of it relates to, that you've seen, relates to the job of superintendent of state police.
Absolutely.
Did you ask him if he kept a personal diary that was non-related to his performance as a superintendent?
We did not, as a committee, ask him.
And as attorneys, do you think that the commingling of personal information and official recording of information gives you some type of privilege that would prevent you from being able to be subject to the subpoena?
Absolutely not.
And I guess the
There's-
chief law enforcement officer should know that also, wouldn't you expect?
Certainly. And to your question, Rep. Johnson, to a witness from state police, everyone was aware that Colonel Reeves kept these notes. In fact, if you talk to a witness, that they describe it sometimes as distracting in these meetings, because they're giving briefings, et cetera, talking about important information, and Colonel Reeves has basically got his head down writing in his journal. There's not been any indication that this journal was kept for personal purposes, and as indicated, we don't believe that that's the test for whether or not it should be subpoenaed and should be produced pursuant to subpoena. The question is whether these records are within the scope of the inquiry and the investigation. And the few records we have, certainly, it's very clear that these records are within the scope of the investigation and are critical to a complete investigation.
And the manner in which he made entries was contemporaneously done in related to meetings and events as they occurred.
And he testified as such. Yes, sir. He testified on that day as such.
I served on the State Police Commission years ago, and we subpoenaed documents and things. I don't know that we ever had the benefit of anything so revealing and potentially enlightening as this. I don't know that we ever had anyone just refuse to provide documentation when subpoenaed, and I'm somewhat surprised by this. Or did you inquire as to whether or not he recorded any impressions, notes, or any type of record by way of audio, electronic?
Unfortunately, we asked about his cell phone.
Yes, sir.
And it was his cell phone was, well, first of all the state police, not all, high-level members of state police's cell phones were wiped by their forensics unit, and then that cell phone was later destroyed.
And Mr. Pro Tem and members, I want to keep it to the resolution. Let's keep it to the end. And I'm just doing a reminder for the whole committee, not necessarily you, Representative.
Thank you.
But I think the question, though, is he's trying to say this may be the only
That's right.
document that is available to us, which highlights its importance to the committee, that we don't have his cell phone records or his cell phone to verify that this is the one document that we know exists.
Yeah, what you said. That's what I was trying to do.
Thank you.
So, is Colonel Reeves still in any way employed by the state?
No.
He receives a pension, or?
Oh, yeah, he receives full retirement.
Okay. Do we have laws in effect that you are to turn over any product produced while under the employment of the state?
Well, the deal, Representative, is this legislature has Article 3 power to subpoena any document that it feels necessary for its committees.
Right.
And so, regardless of any other law, regardless of how the court system works, we have our own defined subpoena power. And that's what we're here about today. So we don't even really need all that, because we, as a legislature, have that ability that far exceeds.
I just wonder if there were additional, authority in which to consider.
There's a lot out there.
Is in the parameters of your request, were they time limited as to how far back you were asking journals entries from?
What we known to be is 3 journals is what he identified.
Okay.
And the date, we asked for as far back as the date of the incident, May 10th, 2019, because keep in mind, Colonel Reeves sent a text to the governor on that night relative to the death and violent struggle that had ensued with police officers. So we limited the production to that date forward.
So you've not requested journals that might show a systematic manner of communication and documentation that perhaps you will want to, but that will show the system and manner of how the system worked in communicating things prior to the date of the incident in question?
You know what, Rep. Johnson, I may stand corrected, because I do remember bringing it back to January 1, 2019 for that very purpose.
Okay.
And that escaped me today, but we did say January 1 so that we could see his system of note taking and then the event and going forward. So it was January 1, 2019.
Is there anything that this committee has done by way of an order from a court or anyone to protect and preserve these journals from being destroyed or being
we have not.
disposed of? Or I mean, not only January 1st, but all the way back to the inception.
We did not. We relied on Colonel Reeves's testimony that he would preserve those journals, whether we would produce them or not. He agreed to preserve them.
Okay. And his testimony has been suspect in that you have found several inconsistencies between what he has testified under oath and what evidence that's been produced has revealed.
Well, look, I'm going to be very frank with the committee. When he was superintendent, I had a great relationship with Colonel Reeves. I've never found him to be anything other than an admirable officer. However, his recollection on some things was very hazy on certain things, so the book provides clarity on some of the details that he could not provide. And I think, I don't want to accuse anybody of anything. So without him being here to testify and clear up any discrepancies that may exist, I do think the book, the journals highlight things maybe he does not remember completely.
Which helps you get to the truth, which is what you're trying to do.
Absolutely.
Okay, thank you. That's all the questions I have.
Thank you, Representative Johnson, for a question. Vice Chair Duplessis.
Thank you, Mr. Chairman, and good morning. I want to just start by thanking y'all for your work on this committee, which is in addition to your standing committees. And you both acknowledge that this is not something you asked to be a part of, but it's obviously been very time consuming and I think a very emotional matter for this entire state. So thank you for your work on this.
Representative Duplessis, I'd be remiss if I didn't insert this right now. We're using regular House staff. So the staff that has to get the committees together, they're doing this on their extra time for us. So we should, while you thank me, I appreciate it. Yeah. But they deserve the thanks even more than me and Representative Villio do.
Always, and certainly want to thank the staff as well. This is obviously a very unique scenario. And I want to just kind of go back to where we are procedurally, what's being sought here today with respect to the resolution and the seeking of contempt that was voted on by the special committee that's being sought to be voted on by this committee, which I believe will be voted on by the full House if we vote this resolution out of committee. I have a letter in our packet from the attorney for Colonel Reeves. It's dated May 23rd. Have y'all had an opportunity to read that letter?
I probably have.
Okay. A few points are made in that letter that question jurisdiction, question whether or not Colonel Reeves was ever actually served. I wanted to just kind of explore that a little bit. If you could speak to I don't know if you had a chance to read the letter.
Yeah, I've read the
Okay.
letter.
Okay. Because this is unique, certainly from my standpoint, and I talked with staff and I asked when was the last time the legislature ever had to exercise this jurisdiction, and I think I was told sometime maybe in the 70s, maybe 73, 79. I'm sorry, I had my years off. Thank you, Trish. But is there any reason to believe that we don't have full jurisdiction to carry out what we're carrying out right now?
No, the case law is completely clear that we have jurisdiction over this, and let me add to that. First of all the subpoena was served on his attorney. We have a letter of representation from his attorney. I know as attorney, you know that's
Right.
the proper way to contact somebody who's represented by an attorney.
Right.
On top of that, I will add that all of our meeting notices have been public. All have been agenda itemed. They've all been noticed properly. There's been no issues. At any moment, anybody could have come and testified.
Okay. And can you tell us just a little bit about where we are in the process with respect to the special committee? So the journals have been identified, and the lack of production for Colonel Reeves has led us to this point. But in terms of the broader scope of where the committee is in its investigation, can you just tell us where we are in that process?
Yes, and look, people ask me that question a lot.
Yeah.
And in all frankness, with the committee, I would have thought we'd been done by now. But every committee, and I think Representative Villa will back me up on this, and I think all members would. We learn something every committee that is almost shocking, and that extends the life of the committee one more meeting, as we have to go run down either something that we know to not be true that's said publicly, and then we got to go find the guy who can come in and testify to the truth of that matter. That said, we have taken on a lot of witnesses. We've worked really hard, interviewing pretty much almost anybody involved. We still have a couple left, but we're also sitting on a lot of documents. And as I told you before, the staff is, they're still doing their civil law staff. They're still making bills for us. They're still doing all the things they do. So this is an additional work for them. So we've been paused for a little bit, because we don't have this journal. And before we move forward with future witnesses, we would like to have the journal to see the information's in it. And so it gives us a good way to proceed. And then we're sitting on other documents that we haven't had enough time to thoroughly go through and vet, and that would color how far it goes.
But in all fairness, there is a likelihood, I'm not saying there's a probability, but there's still the likelihood that there could be other findings of contempt.
Absolutely.
Yeah. I think that's all I have at this time. I'm sure we're
And
probably
look, members, I'd
yeah.
ask you, you have the letters from Representative Oglesby in
Right.
there. And I think it tells you everything. He asked to have this hearing the day after we end session. I mean, I think that should tell this committee everything they need to know about his true intentions and how what kind of faith he's operating under the day after session ends.
Yeah, I saw the June 7th request, and I didn't. Yeah, that stood out to me. Thank you.
And Representative Duplessis, just to let you know, I think jurisprudence is very clear on the courts recognizing their limitation to interfere with legislative investigations and requests for production of records such as this. And the First Circuit has gone on to say that whether these papers and documents are private, personal records is not the true test, which, as we've already stated, they're not. But that's not the test, but rather whether these records are within the scope of inquiry of the investigation. It's that quality of the records that determines the reasonableness of the subpoena. So jurisprudence has been very clear that it's well within the authority and scope of the committee to request and subpoena these documents.
Thank you. Thank you, Rep.
And without the ability to be able to have an enforcement mechanism, what is the use of subpoena power? I mean, if you can enforce it, I think that I agree with you on the case law. Representative Jenkins for a question.
Okay. Thank you, Mr. Chairman. I want to thank both of you and the members of the committee that you've been doing. I think it's necessary to shed light on the facts, bring justice to the family, help to restore confidence in our state police. You answered some of the questions already, so I'm not going to go back over the jurisdiction. But one other question I did have was the amount of the fine. Can any of you shed some light on why we are suggesting or recommending a $5,000 fine?
No, I appreciate that. And I think looking at our powers, and one of the things it says is to punish people who don't comply with our subpoena. That's Article 3. We needed an amount that was sufficient relative to the importance of the document to compel its production. The committee and I discussed that in our committee meeting, and we thought 5,000 was an appropriate number.
All right. Thank you, Mr. Chairman.
Thank you, Representative Jenkins. For a question, Representative Thomas.
Thank you, Mr. Chairman. I too thank you for your work, and I see other committee members here. Thank you for your work. It's my understanding that Colonel Reeves is now retired. Is that correct?
Correct.
And when one retires from the state of Louisiana, is one allowed to take state property?
I do not believe they are, and one of the things we've learned in our committee is that I don't want to be accusatory, but state police has a laissez-faire attitude towards cell phone property and other kinds of things. They're not. It's not well kept.
So Colonel Reeves would not have been able to, for example, take his computer
He should not have been.
or his desk
Should not have been.
or his chairs.
Should not have been.
So my question is, should we consider these journals to be the property of the state of Louisiana?
It's a good question, Rep. Thomas, and I spent some time last night thinking about it and then decided that I was kind of chasing a red herring. And I was thinking about it in terms of, I can't swear because I haven't seen the receipts, but you can bet those journals were purchased with state funds. I would be surprised to find out otherwise. But with that said, that's why I wanted to take the focus off of whether or not they are in fact public records, state documents, and put it on the fact that whether they are or they aren't, we have the authority under Constitution to subpoena those records because we have the authority, the oversight of the department. And so with that and other rules for the committee, we have the authority to subpoena them. And that's why I read the jurisprudence to Rep. Duplessis. It matters not whether they are or they aren't. They were subpoenaed. They're relevant to the investigation and the scope of the inquiry, and they were required to be turned over, and they haven't. And it really doesn't take much going past that.
Thank you. I have one other question, and that is if this House finds that Colonel Reeves is in contempt, does that guarantee that we will be able to, that your committee will be able to see the requested records?
No, it doesn't. We can't subject other than it's almost impossible to force somebody. I mean, to go to his house and collect them, but that would give us an enforcement mechanism to try and compel those records.
Okay, thank you. Thank you, Mr. Chairman.
Thank you, Representative Thomas. For a question, Representative Ivey.
Thank you, Mr. Chair. I really appreciate y'all's work. I mean, it's going to be echoed in staff. It's kind of an unprecedented situation that we're dealing with, and the tragedy for the family and the stain of what's occurred, and y'all, I believe clearly demonstrated in testimony, the stain on one of our chief law enforcement institution in the state. And while it certainly doesn't besmirch the entire organization, the few the specific situation and the cover up, but this one's going to hurt for a while. Our state motto is union, justice, and confidence. Confidence has been lost as a result of this whole situation, and justice hasn't been served yet. And I appreciate y'all's efforts on seeking justice, and hopefully in the end we're able to achieve that. This committee is an investigatory committee, correct? I mean, it is investigation by committee. I'm not in the kind of in law enforcement or prosecution or anything like that. Is this a unique method of investigating something of this nature?
Yeah, I mean, it's unique in the sense that we don't exercise our legislative authority all the time, but it's not unique in that it's some kind of
No, I mean clearly towards that. What I mean is like to go about an investigation, and I'm imagining it's a slow process when it's just in a committee where public notices, getting people there. It's very different than law enforcement investigating a crime where they got boots on the ground, right? And so this does create a much slower process than otherwise than typical. Is that?
That's fair. We have to set up a committee. We have to get notices out, put out agenda items. I mean, everything that we do for regular committee, we're doing for this.
Okay, and so for those of who were wondering how come things are taking so long, it's the process that we have available to us, and it is what it is. But I do appreciate y'all's effort and diligence on this, and we'll hear from the attorney.
And I would add to you, Representative Ivey, that we've only been doing it this session while we're
doing everything else.
And I think it's something that we've talked about a lot as members are here all the time. We're not set up for a whole lot of things in this body. We're set up to do very specific deal that we do. But when you ask stuff like this, it adds a lot of complications.
Yep. Well, thank y'all. Keep it up.
Thank you, Representative Ivey. For a question, Representative Gadberry.
Thank you, Mr. Chair. I guess my one question is in pursuit of the journal. I'm reading here in I guess Mr. Oglesby's letter where he suggested a neutral party review the journals so that the person could advise the House members on whether Reeves had complied or not, whether they were public or private materials. Did y'all pursue getting a third party to try to ascertain that information?
No, in fairness to Mr. Oglesby, he did offer that. I rejected that, and after talking to my members, I've also rejected that for a couple of reasons. One of them is how we're going to pick somebody. How do you pick a third party, neutral party? Who's neutral? And given frankly, I'll be completely frank with you, given the amount of cover up I have seen in this already, I don't trust very many people to actually look at these records and give me an honest opinion. I don't know what's in there, but I need my diligence to go through and find the documents that we need to see. And this at the end of the day, is not a court of law. This is the legislature. This is our authority and our right to these documents. We don't need a third person to look at them. We can do it ourselves. And it's what's in our rights.
And Representative Gadberry, to that end, and forgetting about whether or not there's a trust factor or a lack of trust factor, when you're looking at a case of this magnitude or an investigation of this magnitude and the number of witnesses we've heard from, it would be impossible, in my opinion, to delegate that to a third party. No individual knows what's in my head and what I'm looking for, and what information I may be operating off of, and why I'm looking for that journal, why I asked for that journal on day one of Colonel Reeves' testimony. There is no neutral party that can look at his notes and decide whether or not those notes meet the scope of our inquiry. Quite frankly, I know when I look at those notes whether they meet the scope of the inquiry and whether they satisfy what I'm looking for relative to this investigation and relative to use of force, and whether or not the notes are cryptic, because sometimes they are cryptic in terms of it may mention a parish and use of force in a parish as opposed to Ronald Green. So there's a lot of mannerisms in his note taking that a neutral party, whether you trust him or you don't trust him, but let's just say we trust him, could not satisfy the investigation by the legislative committee members themselves.
Okay, thank you.
Thank you.
Representative Gadberry for a question. Representative Lyons.
Thank you, Mr. Chairman.
Lyons.
Thank you, Mr. Chairman. Representative Magee. So, as we go forward, and I'm looking and listening to the consequences of the fact that being in contempt and the ability to enforce the measure there. So at this point, it appears to me, and I'm asking this question, it appears to me, and I'm asking you to verify this, that the investigation piece as it stands today, is it at a standstill based upon the information that may be needed or is asking to be provided?
It's not at a complete standstill, but it's hurting our ability to move forward.
And that's the part that pains me a little bit, because I know we're trying to get to this point, and in the Colonel Reeves capacity, I would hope that doing diligence and cooperating to this point would do that, and it certainly adds to the presumption that there's much more troubling information that may or not be provided, and I'm not assuming that it is, but it sure leads to that particular point in doing that. So as we go forward with this precedent being set here, and I say that by if for some reason the documents and the journal is provided, there may be other measures that you run into or hurdles you run into like this. This surely would provide the, I'm gonna say, launching point for more actions like this.
And Representative Lyons, this is something that I probably should have said. Our inquiry has been so detailed and going through every stone that has been covered. I think that Representative Villio and I know more about the Ronald Green investigation than Colonel Reeves does. Wow. And he may have notes and documents that he doesn't realize is even important to us, because he may not realize what somebody was telling him or what was being observed was important based off because he didn't have the full picture at that time. We know a lot because we've investigated and asked questions of a lot of different people about certain things, and not only it's been publicly done in the committee, we received this information. I can't go, it's been rarely a week I don't get a phone call from somebody who knows something about the Ronald Green incident who tells me something about it. My point being is, I'm not even sure that Colonel Reeves is even hiding something that he knows to be. It may just be in there inadvertently as a side note, but we don't know any of that because we can't get past only the 11 pages they provided to us.
And this says a lot about the procedure and policies pre this incident and where we were, and for incidents like this. I'll thank you, and I thank my colleagues on the committee. And one thing I think the people of this state can be, I'm gonna say, proud of is the fact that we've come together and you've done the good work that you've done with staff, and I thank you for it. I'm just concerned that the level of, I'm gonna pick the right word here and not say deception, is so so prevalent in this particular case. But thank you for all you've done.
Thank
you, Mr. Chair.
Thank you, Representative Lyons. Representative Farnham.
Thank you, Mr. Chairman. So to get a little context on the contempt part of this, is there a time frame? Say if there's a contempt charge that's held up by this body, and he doesn't comply with the turning over the documents, can this be a repetitive process until he does? Can he be fined over and over and over until he turns over the document?
I think we would have to file another resolution if he does not provide the document, go through the process again.
And there's no limit. It's just to be a matter of how many times you want to go through the process until he complies with the requirement.
Yes. I mean, theoretically, I think this can be turned over to a criminal investigation, and once it's a criminal investigation, I think a judge could take steps to do that. But that's me speculating on judicial proceedings that I think are beyond our scope.
Yeah.
Is there any point in the process that seizure of the state property could come into play?
Not in my understanding.
Okay, thank you.
All right. Thank you, Representative Farnham. We're getting on the second round of questions, so I'm going to invite Mr. Unglesby up now. We have a red card in opposition. Mr. Pro Tem and Representative Villio, if you'll see the table. Filling out a red card in opposition, Louis Unglesby, representing Kevin Reeves.
Good morning.
Good morning.
I've been a lawyer since 1974. Most people know who I am.
If you could please sit, Mr. Unglesby.
Well, when I wanted to say I want to stand deliberately, I will sit.
Well,
Okay? But I've appeared in courts all over the United States with people much meaner and some nicer than you. And I've never, before this morning,
Hold on, hold on, Mr. Oglesby. For decorum, we normally have sit because the recording can pick up. They can pick up your face on the camera. All of those good things that come with recording it. Yes,
Excuse
sir.
me.
That's
Thank you.
okay. If you could pull the mic a little bit closer, I'm not hearing you quite well. Thank you, sir. I appreciate
all right,
that.
folks, I didn't want to be too loud. Never in all that time, publicly or privately until this morning, have I been accused of lying. Now, I take that seriously, and those who ask questions on that question, please follow up with them, because I couldn't keep up with everything you were asking since there were so many issues. I was brought here under a belief that these were very narrow issues, but I see they've expanded. I can't control that, and I'm here to do what I can for you. I wrote a letter that said Colonel Reeves has no Ronald Green documents. He does not. A document means like a state police report, a police report, an official, some kind of official thing. He has none. Colonel Reeves has complied with this subpoena. He gave to the committee all of the entries that relate to Ronald Green. All of them. If you listen, let's keep up with what happened here. Colonel Reeves was initially requested by Speaker Schexnayder to give him an interview. Have all of you listened to that interview? Is that a yes or no? I mean,
Well,
if you haven't, I don't want to guess for it, and I don't want to waste your time talking about something you already know.
Mr. Oglesby, as you probably know by now, you cannot ask us you're free to
Well-
you're free to throw those questions out there. But I just wanted to be clear. Yes,
May
sir.
I suggest to you that if you haven't, in trying to understand the good faith of Colonel Reeves and the good faith of compliance and cooperation with this committee, you need to listen to that interview that he gave voluntarily to Speaker Schexnayder. Speaker Schexnayder was allowed to record it. And he knew it was being recorded, and he could ask anything he wanted to ask about anything he wanted to ask for as long as he wished to ask that. Colonel Reeves sat and answered everything. Speaker Schexnayder left apparently satisfied with the information that had been provided. Then we were asked, would we come to the committee? Colonel Reeves had no problem with that, to answer some of your questions. Yes, it's been 3 years since anything was done. No, it is not at his feet, nor frankly, folks, those of the state police. This investigation was finished as it related to the misconduct of Trooper Hollingsworth, the tapes, the autopsies, the interviews, everything was turned over to the district attorney within less than 90 days. I'll tell you, as a lawyer, you could have convicted Trooper Hollingsworth in less than 15 minutes of a whole array of different cases, had you chosen to. So, today, right now, there's a civil case. Not one lawyer in that civil case has asked anything of Colonel Reeves, has asked any questions of Colonel Reeves, has asked for any records from Colonel Reeves. There are two different investigations. I don't want to say grand juries. There is a federal grand jury that we know of. The district attorney up in North Louisiana says he is going to do a grand jury, but I have no knowledge of whether that's ever occurred. It hasn't, to my knowledge. Neither of those gentlemen or those groups have asked for any of these journals. Reason being, they're not relevant to any of this. What you have, what Speaker Schexnayder wanted to know, what this was all about, is interactions between Colonel Reeves and Governor Edwards. That's what it was. The tape that Schexnayder has, the statement that Reeves read to the committee and all of his testimony, which lasted quite a while, find an inconsistency in it. Look at the records he turned over relating to Ronald Green. Find an inconsistency in it. Now, I wrote a letter to you guys, gentlemen and ladies, because I was trying to figure out, is there a process here? Is there any way to have some rational, reasonable exchange of facts? The pages that Mr. Magee wished to copy are still, as in the letter sent to him and to the committee some time ago, sitting marked in my office. Anybody can come see, these are the pages he thought were relevant. We never had a conversation on whether I could agree or disagree, because it wasn't that kind of conversation. It was, this is what you're going to do, period. Now, sure, a fair-minded, clear-headed person could come and look at those documents and know the answer. Now, let's talk about what has been done. Reeves, when he appeared, was asked exactly and only this question by Representative Villa. Oh, I'm sorry, it's hard to read and talk. All right, I'm going to do my best. If you can't hear me, you tell me, okay? Well, let me ask you this, Colonel, because actually notes that I write here are actually a public record to you, and I would submit your journal is as well. But I want to ask you this question. Your lawyer and I can agree to disagree on that. Let me ask you a question. When you sat in the disciplinary review committees, correct me if I'm wrong, it is pretty widely known that you kept a written journal where you made many notations in order that you could discuss matters with the governor. Is it true that you kept what you refer to as your personal journal, where you made notes in significant cases, like the Ronald Green incident? Is it true you kept a journal? Is it not? Colonel Reeves, I had a notation with journal, yes. I had a journal with notations in it, with my personal thoughts in it, and some of the stuff, yes, that we were discussing at the time. But it was not so I could discuss it with the governor. That's all that was asked of him. Now, Representative Bacala, then, following up, said this: thank you for coming down. One other thing, if you don't mind real quick. I know that you're reluctant to talk or share your logbook, or whatever you want to call it, the journal. Would you be willing to share any information within the journal that is specific to the Ronald Green case without sharing the entire journal? Would you? Would you pick? I mean, we would have to trust that you would give us everything, but is that something you'd be willing to share with the committee? It's just those select entries relative to this case that we're looking into today. He says he wants to consult with his lawyer, and we'll see. Representative Bacala, I don't know, maybe the equivalent of an in-camera inspection, if that would satisfy, or we just trust you to give us anything that may be relative to this. You know, my phone is blowing up. Everybody thinks the journal is, a piece of the evidence that is being concealed, that's going to tell the whole story. And I think, as much as we hate to say it, some of this is about, the public's expectation of this committee. I think it will go a long way toward perhaps meeting our original purpose, which is to gather facts. And it's to the point that it could provide us with more facts to make determinations. It may be a very valuable piece of information. I could appreciate if y'all could do whatever you could to share these entries with us. And he's asked, could you destroy it if you wanted to? He said, I haven't, I won't, and he didn't. Now, Landry only asked says, a couple of follow-ups people sent me. The journal you referenced that you were taking notes on the disciplinary meeting. Do you know where it is now? Yes, ma'am. Do you have it? No, ma'am. I mean, but you have it with you. Yes, ma'am. That's it. So Representative Bakala asked him about what is the jurisdiction of that committee, the investigation of the death of Ronald Grant. The others ask him if he will maintain it, which he does. And then Representative Villa wants to know about whether there are notes in there about him talking to the governor. Now, that's what this is. Colonel Reeves has turned over. If you look at the notes that he gave you, they're correct. They're complete. And the idea that, well, maybe there's something else in there somewhere that we might find that might matter to us that Reeves doesn't even know matters is I suggest, illusory. But more importantly, folks, gentlemen, ladies, Colonel Reeves has the right to privacy. These are not state materials. There's no rule, requirement, recommendation, suggestion, or policy that anybody in state government is prevented from keeping personal records. And that any record they keep while they're working for the state becomes the property of the state. Colonel Reeves did not use state money to pay for his journals. And the idea that that is something that all of a sudden became magically yours, I suggest is incorrect. Now, we can have that legitimate argument, but to all these accusations against Colonel Reeves, and by extension his lawyer, are inappropriate. Now, as to a third party, the construct is simple. Let me see if I can put it in your words. You are asked, probably daily while you're in session, by constituents, lobbyists, fellow members, do something or do nothing, or let me talk to you about a problem I have. See if you can help me. Some of those, I dare say many of them, are really private. That person who's talking to you is talking to you because you have this temporary authority, but he's also talking to you as someone that he's looking for help from. He's not expecting to read about that in the newspaper because in order to remember how to help your friend, you made a note of it. All this idea, oh, well, we'll mark it out, we'll be careful, we'll edit it, we'll do it. Folks, that's not what happened. Didn't happen, hasn't happened. Let's look at what did happen. I turned over the Reeves notes about the investigation to the committee. I didn't give them to anyone. When asked by the media, we hear there's a letter over there at the committee, can we have it? No, you can't. It belongs to them. Did it become a public record? You know that it did, instantly. Was it released to the media? You know that it was. Now, I don't criticize that. I'm not here to, I understood that that was likely what would occur. But that was okay because that's relevant to what they're doing. What was going on with Ronald Green? What was going on with Trooper Hollingsworth? When was Colonel Reeves first aware of what was going on? What did he do? And what was he doing? All of that is laid out very precisely in those documents that you have and consistent with everything he's always said. But the other matters involve other people. Now, had I had my way, which I, of course, don't have, Representative Magee could be explaining to you, and I could be asking him questions about why some of the pages he marked have anything to do with Ronald Green, pardon me. I'm sorry. And you could be deciding, do they really? I'm not here to cast aspersions on anyone's thought process. But I have read the pages that he marked, and they're still there. I dare say that most of you, looking at them, would agree with me that they don't have anything in the world to do with Ronald Green, the investigation of Ronald Green, staff meetings about Ronald Green, changes made or to be made in the state police, because it's all covered in the materials that you have. Now, as to your power, I suggest to you, but I'm just a lawyer, that you have power, but you don't have a process. You have the power to subpoena, and you have the power to say we're going to hold you in contempt, but you don't even have a definition of what that is. You don't have a standard of proof. You don't have an idea of how many people have to vote for or against that particular thing. You have a statute that says the fine is $1,000. I don't know where $5,000 comes from. Could be 5, could be 50, could be 15, could be whatever that group feels like on that day. The rest of us out here have rules. We know what the speed limit is. We know what the consequences are. But it's posted. You posted in Title 24 the fine of $1,000. Now we have a resolution for $5,000. I have asked, it may be a failure of my part, but I have tried to research and ask, is there some other statute of which we're unaware that changed that $1,000? I'm unaware of it. I'm still unaware of it. Maybe today I'll learn. Now, you also have a problem with your process in that you have a committee that gets to decide what to ask for, then decide whether it satisfies them, then decide if they think it's in contempt, then decide how to punish it. Now, normally, in my world, you can't be the policeman, the prosecutor, and the judge. But that's up to you. As far as questions, I don't know which one you want me to answer. I honestly couldn't try as I might, write as fast as I could on my leg, each of your different concerns. I would like to try to alleviate those if I can, or at least give you a specific answer. But I'm not able to, without your help, I'm not able to just regurgitate and review each thing that you were asked. We do not agree that these are public records. So that's a debate. And we don't agree that it's clear at all in law that they are public records. But, again, we have offered, continue to offer, the point that we'll abide by Representative Gadberry, not argue with, but abide by whatever, if there were such a person or persons, the third party said he or she thinks may be relevant to the committee. We will abide by it, even to the degree that that individual or individuals, had they been or were they ever selected, could conference privately, not with me, with Mr. Magee or Representative Villa or whoever he wanted, and say, okay, here's this page. Now, why do y'all really think you need this? It doesn't appear to me that you do. Or, here's this page, I think you need it, and I'm giving it to you. We've always said we'd do that. We have always said we'd do that. I'm saying we'll do it today. What people don't understand, someone doesn't seem to understand here is Colonel Kevin Reeves is not the cause of any of the problems that are being investigated, nor did he harm Ronald Green, nor did he fail in his duties in any way. The minute that the district attorney gave him authority, which he had to wait for, the minute he got authority to go forward with discipline of Chris Hollingsworth, it was done within 3 days. The U.S. Attorney's Office, Mr. Van Hook, and the district attorney, and Mr. Belton, ask that you not reveal these videos. Now, that's just the facts. I don't know who Tina is that's referenced in there. I think Tina is someone related to the governor's office. But she's the witness as to whatever videos she's talking about. Not Colonel Reeves. His being brought in here and made a symbol of I don't quite know what is not fair. It's not fair. He's a retired citizen of the state of Louisiana. He could have said, I'm not coming to this committee. He could have said, I'm not going to participate. Some have. He felt it was his duty and his obligation since he was the colonel. He's the captain of the ship. He's responsible for what happened. He's never shirked his duties. He's never tried in any way to make excuses for what happened that night. And when he was given the opportunity to invoke discipline, the man was immediately fired. His people, there's a process of how you investigate a crime. It was investigated. The evidence was gathered. There's not any different. While this committee may be learning a lot of things that's interesting to it, as far as the evidence of the case, that's been done. That gumbo was cooked a long time ago. Unfortunately, the person that was available to be prosecuted died, most likely by his own choice. That is no way, shape, or form the responsibility or fault of Kevin Reeves. The fact that it took over a year, or close to a year, before he was allowed, given the right by the law enforcement agencies to discipline the people involved, is in deference, as always, in the tension between the police and the prosecutors. There has to be that. There has to be the police gather, the prosecutors determine. That's the process. The colonel can't interfere with that and can't override their request. Now, he's answered all these questions, and he has honestly provided everything that's relevant to this case. All the rest of this is sort of speculation, and I don't know. I don't have an answer for you, okay? I don't know how to answer you, but I'm ready to try.
Okay, let me just ask you a few questions.
Have
And
water?
yes, sir, of course. Yeah, I'll give you a second to pour some.
Oh, you don't have, I can listen and pour.
Okay. Mr. Unglesby, are you aware of a subpoena ducis tecum that was issued on April the 19th, 2022, directed to Colonel Reeves through you as his counsel of record?
I'm sure so. I mean, I don't have the package or anything, but I'm not disputing that.
Okay. And is Miss Lisa Westmoreland an employee of yours?
Yeah, it's all, everything they said is true.
Okay. Okay. Well, I'm just walking through. So, we have documents showing that the subpoena was we received service that was issued through Miss Lisa on April the 19th, 2022, requesting that the journals of Colonel Reeves be turned over by, let's see, 4/26/2022. Are you aware of that?
I accept everything, as I said. Okay, the scenario of did they send a subpoena? Did we comply with it? No.
Okay.
Was there an agreement made to review the journals at my office? Yes. Was there a visit to my office? Yes. Were the copies of the the things that relate to Ronald Green or the events of Ronald Green copied and there for the committee members? Yes. I didn't know they were deliberately left there. I thought they were an accident.
But so you're aware of the subpoena. You're aware that you were served with the subpoena, and did you or Colonel Reeves comply with the subpoena by turning over the journals by April 26, 2022?
No.
Okay.
We know we didn't.
Okay. Yeah, Mr. Unglesby, just they can't hear you. Yes, sir. Okay, I'm going to go ahead and move on then. And the first question in the queue is going to be Representative Ivy.
Thank you, Mr. Chair. Hold on, I've got to back up a few pages of notes.
Am I doing better now? Can you hear
Yes,
me?
thank you.
Okay.
Yes, sir. Thank you.
All right, you specifically said in course in one of your letters, no Ronald Green documents, and you and what is, because you kind of elaborate a little bit, could you refresh my, what is a Ronald Green document?
Okay.
If you're trying to comply with, quote, providing all Ronald Green documents, what would constitute that?
I would say, for example, police report. I would say a internal affairs report about the investigation, any information from the district attorney.
So obviously all formal reports, right?
Or in informal reports internally if there were, I don't know, I'm making this up because there weren't any, but if there were,
would an email, like an email communication be one?
Right.
Would a text message?
Sure, but let's stay where we are, Representative Ivey.
Okay.
So yes, that's how I would define documents. Okay. And secondly, I think if you read the letter, I believe, I don't have it in front of me, sir, but I believe it does identify that if there anything regarding the journals or the journals are referenced. But you have to remember, ladies and gentlemen, Colonel Reeves retires in October of 20. He can't go to the state police headquarters and say, give me some stuff, because the subpoena, I have a group that wants it. He doesn't have that kind of authority. The state police can. He can't. So he did not, and does not have any documents, as I would define that word, or as I think the law defines that word, that relate to Ronald Green.
Okay. So you just said that a text message would be a document relating to
said if he had text messages that related to Ronald Green, we would give them.
Well, no, I was asking you, would a text message about Ronald Green, would that constitute as a document? And you said yes.
If Colonel Reeves had it, yeah.
Correct. And so something as simple as a text message would be a document about Ronald Green. And so would a note, right, the same exact thing, same text that was texted to on a phone, which you just said would be a document, would the same exact words in a little notebook that somehow not be classified as a Ronald Green document?
I don't think so, but you have them. You gave those.
Right, but
I don't have.
And again, I haven't been
You
able to
got
go
me.
through all this, and so I promise I'm genuinely trying to understand this. So, was it your position that he had no Ronald Green documents at all, and then did you make it a separate issue that do you maintain that you have no Ronald Green documents and that the journals and all of its contents are not Ronald Green documents? However, any references, okay, is something that y'all have you claim to be willing to provide.
I think the thought process was any references to Ronald Green, that he had anywhere would be within the scope of the authority of the committee. And so, in good faith, he would provide them.
Right, but is the journal or any page in the journal, is it a Ronald Green document?
The pages in the journal that were turned over, we can, if you want to call them Ronald Green documents today, fine. That's not how I referred to them. I referred to them as journal entries or notes or something.
Correct.
But here's the thing. So you understand, Representative Ivey, the journals were provided to the committee to check that. Just here's the originals, here's the copies for you. You can see that the originals and the copies are the same pages.
Okay. Do you know if the actual physical journals were either purchased directly by Colonel Reeves, or was it something that he, pulled from a, supply closet, something is that typical? Because people make journals, and it's especially different professions. They log stuff because they deal with so much information. And so it's customary, and even in my business, that we provide those resources to our staff so they can do that. Do you know if that's the case or not in this?
I have no idea.
Okay.
I honestly, I have no idea. To give you a straight answer on that, I think that Colonel Reeves, in my memory, I think Colonel Reeves as a human being goes through his life, probably in junior high school was a good note taker.
Sure.
I don't know.
Well,
for
we
sure.
have to take notes here because again, I understand, but is anything contained in those journals? Is there anything in those journals, content-wise, that you would say is a public record? I mean, I'm not talking Ronald Green. I'm anything.
A public record?
Yes.
A representative? No, I would not. No.
So there are nothing he has written in any of those journals about his work, his duties and functions as the colonel. None of that information is public record.
I don't think that it would be, but I mean that's just me. That really.
But
would
a text
be.
message is a public record.
No, you asked me if he had any text messages. Would I consider those documents? And was
Right.
something we just like the notes in the journal.
Okay.
We're just making a distinction between the
Okay,
hypothetical
I'm gonna
word
move on.
document and information.
I appreciate. Look, I'm gonna move on to public record.
Okay.
Okay. So is a text message sent?
And Representative Ivey, I want to, this isn't just for you. We're going to have a lot of questions. Members, we're here today to discuss a resolution about whether or not Colonel Reeves should be held in contempt and whether or not he complied with the subpoena issued by the committee. So just try to keep the questioning in that framework of what we're here to discuss today. Representative Ivey, I'll let you continue.
Thank you, Mr. Chair. And my line of questioning is to try to find out, and you can provide any clarification on if I'm maybe hunting down the wrong trail, but is if they're arguing that it's not a public record and therefore they don't have to comply with the subpoena. Is it a material difference if in fact it is a public record and they don't comply with the subpoena?
I will tell you that, and this is just my opinion based on the case law I've read and reading the Constitution. It does not matter whether it's public or private. We are given the authority as the legislature vested in the Constitution in Article 3 in order to be able to subpoena documents relevant to whatever we're doing in the scope of our duties here as legislators. So regardless, the question here today, as I see it, is was the subpoena complied with or was it not? And it's really that simple.
Okay, thank you. I'm going to skip right to the end and specifically relevant to this. You gave a lot of examples of what you tried to do and what was relevant and what's not. But the request was to provide the journals, and y'all chose not to, correct?
Yes.
Okay. And do you believe that the legislature has the authority to request these things and then subpoena them if they feel it's necessary?
Can I hate to keep lawyering this, but I'll respond to both you and Representative Stefanski, okay? Independent of public versus private, relevant is important. If these are not public records, and I don't believe that they are, then they're the private property of Colonel Reeves. The portions that are relevant to the jurisdiction of the committee, he in good faith provided. That is not a carte blanche invitation to all of his information, all of his personal property.
Right. So
we make a
you do
distinction.
make the distinction that you do not have to comply with the House of Representatives subpoena for these records on the basis that they're not a public record.
No, I make the well. Okay, that's a fair question, but that's to try not to cut the ham too thin. Simplistically, my position, Representative Ivey, is that we did comply with the subpoena. You know, we did turn over all.
But the subpoena didn't ask for the ones that were specific to what you think the committee was interested in seeing. It asked for all of the records, the entire journal.
It did,
and so how can you say that y'all complied when the request specifically was for the entire journal and you only turned over what y'all believed was relevant to the Ronald Green investigation?
Because we did turn over what is relevant to the Ronald Green
But
investigation.
was that the request?
And I don't care. Pardon me, sir.
Yeah, was that the request? I'm just trying to establish what the request was.
Mr. Oglesby, your mic. Yeah, just apologize. Sir.
You know, gentlemen, we live in a outside of this chambers. We live in a world of laws, and we follow those laws. Now, Colonel Reeves could have just said, I'm not going to give you anything. And if you want to try to get it, sue me. Come to Jackson Parish, exercise your legislative will, we'll see what happens. We could have had all kind of legal processes, but we didn't. Now, we also don't have any way, Representative Ivey, that I know of, we don't have any methodology that you folks have created that gives him the capacity to say this subpoena is overbroad, this subpoena intrudes into things that have nothing to do with the work that you're interested in. This subpoena has nothing to do with my work in certain areas. We don't have a way to do that. In court, so that's one of the frustrations, I guess, that we face, perhaps all of us. Had, for example...
And I'm sorry to interrupt, but out of respect to the rest of the members on the committee, I do want to get through the last few questions I have, okay? So if the document or the journals are determined, and I'm trying to understand your legal opinion, if it's determined that those journals and the contents in them are at large, if not entirely, would be considered a public record, do you believe at that point you should turn those over, or that he should turn those over?
Well, it doesn't matter what I think. It matters what Colonel Reeves thinks. But if they were determined...
Mr. Oglesby, the microphone, please. Yes, sir. No, I'm sorry.
If they were determined to be a public record, then I would think that he would do that.
Well, not would, but would he have to comply with the subpoena if it was determined that it was a public record?
Honestly,
you're an attorney. You've been practicing a long time. I'm not even an attorney. I just do this
I
for
understand
fun.
that. The difficulty we're having is that we don't, respectfully to everyone, we don't have a good set of precedents, and we don't really have a methodology to have someone decide the answer to your questions. But the question that I'll answer for you to maybe solve everyone's problem. Reeves does not now, has not ever, and won't tomorrow argue with turning over anything in those journals that someone determines to be legitimately connected.
Someone
to
determines to
Ronald
be.
Green.
Okay, who's the someone who that determines to be? Who's that authority?
That has, I suspect, Representative Ivy led to this problem that brings me here today.
Okay, and then again, I'm trying to move through the last couple. So would, again, Ronald Green document or something in the journal that you feel in his sincere attempt to comply? Okay, I won't doubt that. It is any notations on any potential disciplinary actions on any other officer that was involved in the incident? Because we've got one guy, he's a great scapegoat because he's not here. Okay, and look, one guy didn't violate, didn't commit this crime. Okay, one person didn't. And so would any notations with respect to, disciplinary actions or, into any other officers or that, would that be considered a, quote, Ronald Green document?
If it were a disciplinary action about an officer for his actions involving Ronald Green.
So yes. Okay.
Yeah.
Okay. Just wanted to see how broad that was. And that's it. Thank you for your time.
Thank you, Representative Ivy. I know we got on this public versus private debate. Mr. Oglesby, and I'm not going to pepper you with case law, but there is a case out there, ASP versus Capital Bank, which was a First Circuit case decided in 1965, which involved contempt of the legislature, and specifically the court opined whether these papers and documents are private, personal records is not the test, but rather whether these records are within the scope of the inquiry and investigation. It's that quality of the records that determines the reasonableness of the subpoena. And so, but when I went on my tangent about public versus private, that is one of the references I was using.
You want to know why we disagree?
Why do we disagree? Because you don't.
In 1972, we passed the Louisiana Constitution. Your case is in 1975, and in 1972. We enshrined in the Louisiana Constitution for the first time the right to privacy. And that case did not deal with the right to privacy. I'm not saying I'm right or you're wrong. I'm just pointing out
why we may disagree. I would
a distinction.
No, absolutely, and I would point to the fact that with limited case law in here, we oftentimes, as you would know, as a much more what's the right term? I'm not even going to use what term I was thinking in my head. As a person who's been practicing much longer than me, you realize that when we have limited case law, we have to go back sometimes all the way to the formation of some of these statutes. And so it is not irregular to go back to a case that even is before the Constitution to try to be able to grasp some sort of case law that gives us the precedent of why we're here today. Representative White? Yes. No problem. Representative Jenkins for a point of order.
Well, yes, okay. I'm just trying to be clear. The April 13th letter of April 13, 2022, that letter from Mr. Oglesby, that was in response not to a subpoena, but was to it represents a request that was made on March 29th?
A request for just a pure, I believe, email request for the production of those documents, which following that came the subpoena.
All right. Okay. Thank you.
Yes, Representative Jenkins. Representative White.
Yes, Mr. Oglesby. I can't say your name, but
Oglesby.
Isn't there a federal investigation going on right now?
Yes.
Okay.
To my knowledge, yes.
And it's 3 years. It's been 3 years.
Well, that's clearly so.
Right. And you talked about when you first got in here, we asked you, there was a direct question about the records that were requested, and you said we didn't comply, and then later you have said that we don't have to comply because you don't feel that the private notes are relevant to this.
I don't think that Mr. Reeves private notes or public record pardon me, ma'am, I don't think that Mr. Reeves' private notes are within the purview of the committee jurisdiction beyond those that, of course, relate to the issues of Ronald Green.
Well, I want to bring up about the notes, about what you're saying. You're saying they're not, that we shouldn't have access to them. But when we went through redistricting, we were clearly told that any note that we took, anything, any text, anything that we wrote down would be public records going through that process. The process that you keep questioning that we have, that you don't understand why we're doing what we're doing. Well, if there's nothing to hide, then there should be no issue with turning over the records.
Representative White, we've tried 10 ways from Sunday to find a common ground here. All right? Please hear me clearly. All of you. There's nothing to hide. That's not Colonel Reeves' concern at all. I explained to you earlier his concerns of his obligations to people that he wrote things about that relied on him. As it relates to anything he did as a state colonel, it was done in public. Really doesn't make any difference. Let's say, hypothetically, he wrote down, I think I should discipline Joe Smith, you know? And turns out later, they have a hearing, and they determine that they're not going to discipline Joe Smith. What matters is not what Reeves was writing down he was thinking. What matters is what did occur. And that, of course, is public. Now, I don't know about your redistricting things. I can't comment on that. I know this. If the legislature's now taken the position that everything everybody writes down in any kind of notepad or journal or jots to themselves that's working for the state of Louisiana becomes a public record, you're going to have to build a bigger building to keep all that archived.
Well, this is the issue, is that he stated that he kept a journal during one of the hearings.
So he said it.
So he said it. So it was clear then at that time that there was relevant information in that note-taking, that in order to find if there's issue with a cover-up, then it would have been noted. We could retrace the steps, and that's
You're not
going
to find any cover-up involving Colonel Reeves, Ms. Representative White, and that kind of word, putting him and that word in the same sentence is very unfair. Now that, ma'am, you give me a courtroom, and it'll take about 15 minutes, and we'll be finished with that issue. With all due respect, I didn't mean to speak harshly, but name calling is not normally what legislators who represent the state of Louisiana do. And I suggest that maybe we revert back to that kind of comity. I'm here in good faith. Reeves is here in good faith. Just as Schexnayder, Representative Schexnayder, did not like the fact that Reeves said he didn't canvass with the governor and he didn't have any secret meetings with the governor and there were no agreements to hide or diminish the evidence in the Ronald Green case. The fact that he didn't like that answer doesn't change that it's true. And please, all of you, get off this idea that there's a cover-up. Folks, without criticizing anyone, all the district attorney has to do in September of 2019 is file a bill of information against Chris Hollingsworth for half a dozen different crimes, from malfeasance in office to murder. You've got the evidence there. It's there then, it's there now. It hadn't changed. And there was no effort to cover that up. None. The media didn't break this story. There was no massive whistleblower. All of these videos were there. Were there, are there, the way that works, apparently, it's a good process. They can't be hidden or destroyed or altered. You know, it's an impossibility. Technologically, I don't understand it, but I think I'm right, what I said.
Representative White, back on your questions.
Yes, so we're just trying to clear up so that we know that there isn't a cover-up. And the note-taking is an important part of that process, as I've understood from members that are on the committee. And it really doesn't look good, perception-wise, to hold something back that you're saying is not relevant, but people on the committee are saying it is, because it can lead to other things that we don't know about. You can't ask questions if you don't know, if you can't follow the trail on that.
I thought I made this clear. If I didn't, it's my fault. Let me try one more time.
Okay.
There's a set of pages that Representative Magee marked that you don't have, but they're still there and they're still marked. And we don't care if somebody wants to come read them. What happened was we never had a dialogue. I'm going to suggest to you that legitimately some of these things are irrelevancies. The consequence of giving the documents we gave was that the committee decided, which is perfectly legal for them to do, to make that a public record. The journals that Colonel Reeves have things in them about other things, other people, other events that have nothing to do with Ronald Greene. To just here take it after we've seen that what we did give was immediately disclosed as a public record, and after the belief, apparently, of at least Representative Ballou that there are public records, so that the first time the Morning Advocate asks for it, you must give it to them, okay? Those journals have things in there that when the people talk to Kevin Reeves about them, he never intended, I suggest they never intended to have circulated around the legislature or the state. It's that simple, okay? He's a note taker. You tell him something in confidence, ask him to do something for you in confidence. To be sure that he doesn't forget, he writes it down. He's not intending to violate your confidence ever when he does that. This is culmination, you see here, of two different things happening. And that's what has led to, I think, the confusion. That's why I continue to say that the only reason I suggested a third party is to square that circle. You know, not to diminish anybody's opportunity to look at whatever they want to look at if it matters. But there is no way, at least there was none, has been none so far, okay, to say, okay, page 6, we want line 4. You know, the rest of page 6, you can blank it out. That's never happened. It's been, we want all the journals, period. Give us the journals, give us the journals, give us the journals. Now, we're not hiding anything, and Kevin Reeves himself is not concerned for a second about himself in terms of these journals.
Well, that's good, because we would like to see them.
Well,
if he's not concerned about it, then there should be no subpoena or anything, and just turn them over. And as they've told you, it's not like we're all going in the office to read this. They're under seal. So if there's no issue...
You just said something. Excuse me.
Okay.
If I may. The first time I heard under seal is this morning. So let's not, if you want to hold this man in contempt, let's not make up some new rules that would solve the problem and then say, well, now we've solved the problem and so now you're in contempt. If you want to say they're under seal, I will certainly consider that very seriously. I'll talk to Kevin Reeves, and I suspect you will get a positive answer to that question. But that has not been. Okay, that has not been.
So, Ms. Oglesby, you're saying that offer's never been made to you or Mr. Reeves?
No.
Okay.
Okay,
I
so
don't fault anybody for it, but I'm just telling you that the word seal or privacy or anything like that hadn't been talked about ever.
So we may be with this contempt charge that we're talking and we're looking at today, and the process is that we would vote on this as a committee and we pass it to the floor. The House floor would then vote on it, and you would be, or Colonel Reeves would then be in contempt of court. That's the process.
Contempt of the legislature.
Contempt of the legislature. That's sorry about that.
For today, right now, where you are, yeah. If
Yeah.
you want to change the deal, I mean, not the deal. If you want to change the process, and we want to talk about putting things under seal, stuff like that, I don't know that we'll be in contempt because I don't think we have any objections.
Well, that's good. That's good. I'm glad that that came out in our discussion. I yield.
Thank you, Representative White. Would you be agreeable to us standing at ease and seeing if Mr. Reeves would turn those over under seal?
I think I can. Yes, I'm happy for you to stand at ease. I'm almost confident I can answer you right now, but I will.
Why don't we confirm that, and you can maybe converse with the chairman of the special committee and see if there's not a resolution without us having to take action today.
It'll take me 1 minute.
Okay, members, we're going to stand at ease for 5 minutes. we're gonna come back off of recess. Mr. Unglesby, do we have any developments?
Yes and yes. The only thing Colonel Reeves asked is that in his journals, he believes he's pretty confident that he has written down some personal financial information, Social Security numbers of his family, things of that nature. He'd like an opportunity to either X out or extract that. Otherwise, he has no problem. We can turn him over by 4 o'clock tomorrow.
Representative, Ms. Pro Tem, as the author of the resolution, can you come up to the table and join us? Mr. Pro Tem, with that offer, do you still want to? Do you have any comments? Do you still want to proceed with the resolution?
Yeah. So here's my issue. Once he exited it out, I don't know what it is. It could be anything that he X'd out. We would make the agreement that we won't release anything with financial information, personal or otherwise, without being redacted. But I can't agree to allow him to basically edit the documents at this point. That would be a derogation of my responsibility in the committee. So I will accept it under seal. Nobody in the public, just like we got the other record, state police can see it. None of that information has ever been made public that's in those documents. And if those documents were ever released, I can agree that we would redact any kind of personal information altogether, whether it's financial or otherwise. That's all what I can offer him, but I cannot offer or agree to anything that allows him to edit the documents after the fact.
Okay, how about
Mr. Unglesby?
one of you folks come over to my office, we'll show you the pages that he wants to extract.
I can
You don't
agree to
agree, you don't agree. But, you know, you're going to see that what they are is exactly what I told you.
Okay. Mr. Pro Tem?
I will agree to go to his office, and I want to be very clear on what we're agreeing to. I will allow him to withhold or redact any personal financial information on agreement of us, but the other pages will be produced to the committee.
Mr. Unglesby?
I did not say. Let me look, y'all. We're giving up a lot here. I don't mind. But there'd like some commonality. I'm not interested in having somebody come to my office who just called me a liar. I'm not interested in ever speaking to that person again. And it's better that I not. Okay?
That's the offer.
No, I'm not finished. And so you want to send somebody, we'll accept whatever emissary you want. Okay? Just not Tanner Magee and not Ms. Vila. You send anybody else you want to send, we don't care.
Look,
you can send.
I want an injection real quick.
Hold on. Let's let Mr. Unglesby finish, and we're going to go. We're not going to talk over each other.
I don't want to be in another circumstance that involves the unpleasantness that I've endured up to now. This is very, very simple. Representative White has a solution. We accept the solution. We're not trying to hide anything. We just said, can we take out personal financial information? Kevin Reeves isn't even positive for sure, as we're sitting here, if you had him take an oath, that there's any in there. You know, he wants to come down and look and see.
I understand. Look, and Mr. Unglesby, just to be clear, I'm the chairman of a committee where a resolution is pending in front of. I have the author of the resolution, and I'm going to give him deference to decide whether or not he wants to move forward with the resolution. But if he doesn't want to move forward, you know, it's his prerogative on whether or not he wants to push, and then this committee's prerogative on whether or not we want to move it forward. Mr. Pro Tem, what about this?
Well, hold on. No, I want to address a couple of things.
Go ahead.
First of all, I've never called Mr. Unglesby a liar. I said he lied to the committee about the no Ronald Green document. That's a fact of his contempt, why we're here today. I have to present that case. Second of all, I'm getting offended by the fact that he only refers to the men on this committee as representative, and it's Miss Villio, and it's Landry, and it's everything else. He chastised Representative White for saying something, I don't remember what it was. He's shown nothing but contempt to this committee today. Today. Not on all the past actions. I'm saying the way he's talked to us, the way he's condescending to us. And what I'm offering him is to go for a very narrow set of pages that he claims, which I believe people in this committee may have heard him say before, was tons of personal financial information, tons of personal information. Now he's not even sure if it is in there or not. The story's changing by the second. But what I would like to do is I will allow myself, and I'll take somebody else with me, Representative Stefanski, me and you can go together to his office. We can look at the
Mr. Oglesby, if I go along with my good friend Mr. McGee, is that agreeable?
Yes.
All right, under those circumstances, Representative McGee, do you feel can we voluntarily defer this resolution at this point with the understanding that by 4 o'clock tomorrow, you and I will go and if we are able to retrieve these journals under the conditions that were laid out, we won't move forward with the resolution.
Mr. Chairman, can I ask for
Point of order. Point of order from Representative Jenkins.
and that whatever production is at this point would be under seal. Is that
That's my understanding. Yes. Right? Yes, Mr. McGee?
It'd be under seal.
Another point of order, Representative Ivy.
Thank you. Would it be possible, since we've already done this, to just maybe move this to the floor and pending, compliance with the agreement, we can hold the resolution?
I'll note your suggestion. I'm going to defer to the author on the way he wants to handle his resolution, and if it comes to a vote, then the committee will have to make their own decision.
Look, Mr. Oglesby has represented everybody from Barry Seal to the cocaine cowboys, and now he's got the superintendent of state police. I'm a humble lawyer from Houma, Louisiana. I don't have a big house in Jackson, Louisiana that you can come threaten me with. But I will agree.
Representative McGee, let's
hold on, but let me finish.
I know we're not going to get personal.
I'm
though.
not getting personal.
Okay.
I've never said one thing. I will agree and hold him at his word that if we could go to his office and look at the very narrow set of pages, it sounds like it may be 2 at most, that he produce all the journals by 5 o'clock tomorrow, save the 2 pages that he believes, 4 o'clock, whatever time period. You and I can go. We can look at the 2 pages he doesn't produce. This is what I'm saying. Produce everything else to us under seal. Withhold the 2 or 3 pages that he believes are not part of the journal. And me and you can go and look at those 2 or 3 pages that he's withheld from us and determine whether they're worth being withheld. That's what I think is the appropriate. If he agrees to that, then I will agree to defer this for now.
Okay. Mr. Oglesby, does that sound fine?
That's
Okay,
what I thought we
good, great. I'm just a humble mediator, apparently, from Crowley, Louisiana. But you have a point of order, Representative Thomas? Or do you have a question? Because we're about to take action as the author wants to defer. So, a point of order.
When Representative Ivy was questioning Mr. Oglesby, he asked him if text messages were considered to be documents, and the answer was yes. And so, as I'm looking at the subpoena, it is what was subpoenaed was the written journals and similar documents. My question is, are text messages considered to be among the similar documents? And does the committee wish to have those?
Representative Thomas, I don't want to, again, I want to keep the scope. The author it seems like we have an agreement. It's the author's resolution. Should that not work out and the resolution is pending in front of this committee, I will reopen it for all the questions again, and we can have that debate. But it appears we have some sort of understanding. That's what we're going to do. We have an agreement. With the pro tem's agreement, we're going to go ahead and I'm going to move that we voluntarily defer this what number is it? House Resolution 128. Is there any objection to voluntarily deferring House Resolution 128? Seeing no objection, that's what we're going to do. Thank you, gentlemen.